everyone. My name is Yori Chang with the Center for Labor and Just Economy here at Harvard Law School. Thank you so much for coming to our event this evening, Labor Market Competition and Workers' Rights. We've had the privilege of having staff of the Department of Justice Antitrust Division on campus with us today, and last but not least, we're so excited to bring the broader Harvard Law community together with this panel conversation. It's my honor and privilege to introduce our distinguished guests for this evening. On January 14, 2022, Doha Mekki was appointed Principal Deputy Assistant Attorney General for the Antitrust Division of the U.S. Department of Justice. As Principal Deputy Assistant Attorney General, Ms. Mekki supervises more than 650 attorneys, economists, paralegals, and administrative professionals who investigate and prosecute civil and criminal violations of federal antitrust and other competition laws. She is responsible for overseeing the division's civil enforcement, criminal enforcement, litigation, domestic and international policy, advocacy, and economic analysis programs, as well as the division's operations. Ms. Mekki joined the Antitrust Division in 2015 as a trial attorney. She later served as counsel to the Assistant Attorney General for Antitrust. In that role, she focused on civil antitrust enforcement in healthcare, sports, and digital markets, as well as criminal enforcement in labor markets. Beginning in 2021, she served concurrently as the Antitrust Division's Special Counsel for Labor. In that capacity, she helped advance the division's civil and criminal enforcement in labor markets. She's a two-time recipient of the Assistant Attorney General's Award for Distinction, and she has testified before Congress about competition in labor markets. Ms. Mekki will be in conversation with someone who needs no introduction in this room, Sharon Block, Executive Director of the Center for Labor and a Just Economy and Professor of Practice at Harvard Law School. There will be some time for Q&A at the end, and we'll hope you stick around to join us for our reception. And before turning it over to our speaker, I wanted to say a quick thank you to Danielle Jory and Karina Lubell from ATR for holding coffee chats and speaking with our students at our lunchtime workshop, which was co-hosted with the Program on Law and Political Economy. Special thank you to Sanjay Jolly, who directs LPE here at Harvard, Gilbert Placeres and Anjali Kata from the LPE student group, and my terrific CLJE colleagues, Giovanni Thomas and Taya Berg. Without further ado.
Hello. Can you guys hear me well? Okay, awesome. I could get up and give like a polished, wonderful speech, but as you guys can clearly see, I'm the kind of person who flew up from Washington, D.C. today in a bright fuchsia suit, ready to talk about antitrust and labor. And so if you'll indulge me, I would love to be comfortable before giving some remarks and then turning it over to the Q&A portion with Sharon, and then also taking some questions from all of you. So at the outset, I have to say what a privilege it is to be here. The Justice Department is a really busy place, and every time we get to go on the road and talk to students in particular, I think you will hear both the Assistant Attorney General and I and others in the front office say what a treat it is to interact with students, because there's renewed interest in antitrust. It makes us more hopeful about the future, and it makes us really excited to share our experiences and then hear some of the things that are on your minds. And so if you are here, you maybe have some interest in antitrust, maybe some specific interest in labor antitrust, or maybe you're just here for the free food. But regardless of what brought you here, I will do my best to make this an interesting conversation. Yuri, thank you so much for the biographical details. Again, I'll spend just a few minutes talking about my path to labor competition work. It is possibly the brightest spot of my professional career so far. It's been the funnest thing that I have done since graduating from law school now 13 years ago. I like to say that I did not choose the labor antitrust life, it kind of chose me. And so if you will indulge me, I will take you through time and buckle up, because we're about to go through about 9,000 years of human history. That is not an exaggeration. I came to the Justice Department in 2015 as a line prosecutor, and I was investigating a merger, and that means reviewing a lot of documents and deposing executives and trying to make heads or tails of the facts and the law before making a recommendation to political appointees. There was the Obama administration at the time, and I was thinking about this merger when the team saw a document that seemed like very, very senior executives of a multinational corporation were talking about their conspiracy with their single largest rival, another multinational corporation. And it looked like a no-poach conspiracy, which many of you know is when two companies agree that they're not going to compete for labor. And so we had not seen anything like this in my section at the department. We were not sure what to do with it, but we did know that a few years before, there was a fantastic team down the hall in what was then called the Networks and Technology section that had challenged some no-poach agreements between and among Adobe, Apple, Google, Intel, Intuit, Pixar, Lucasfilm, and eBay. And we talked to them, and they gave us their best guidance and best research on no poaching agreements and why they theorized at the time that this was probably a per se violation of the antitrust laws. Those of you who have taken antitrust know that we reserve our harshest condemnation for per se unlawful agreements. That is price fixing, that is bid rigging, that is market allocation. It's the stuff that we put people in prison for. It is a felony at the federal level, and individuals can go to prison and pay very hefty fines for those types of violations. And so to make a long story slightly less long, we ultimately resolved the conspiracy, but not before October 2016, when some guidance came down from the DOJ and FTC's front offices indicating that going forward, the agencies, where warranted, would criminally prosecute those kinds of agreements. And you have to understand that this had not been done before. In fact, there were not that many opinions treating these agreements, even in our civil enforcement. And so we resolved this agreement and essentially decided that we would exercise our prosecutorial discretion not to criminally prosecute these agreements because they had terminated by the time the guidance came down in October 2016. To be clear, that guidance came down October 20th, 2016. And you might know that a couple of weeks later, there was a small matter of the election. And there was a transfer of power, which is not unusual for all of us at the Justice Department, right? The nonpartisan career staff is used to changes in leadership. It is a perfectly normal thing. And setting aside some particularities of 2016 that made that event unusual, I think we were curious to see what would happen with this policy. And I'm really very glad to say that when new leadership at the Antitrust Division came in, a guy named Mekki led the Antitrust Division from 2017 until January 2021, and he saw the unlawfulness of these kinds of agreements very clearly. But he also recognized that we did not have a ton of experience, as a policy matter, implementing this guidance. And so as a line prosecutor, I was asked, would I come up to the front office and serve as a counsel to the AAG and try to help make heads or tails of this policy and figure out how we were going to treat these agreements. And this was a really fortuitous opportunity for me. I came to the front office in April 2018 thinking that I'd learn about criminal prosecution and prosecute no poaching and wage fixing agreements, which we did ultimately do. But in the process, I learned a lot about the antitrust laws, and this is the thing that I hope all of you pay the most attention to. Raise your hand if you've already taken an antitrust law class at Harvard. Okay. Those of you who have not taken the class, don't worry. There's probably still time. But even if you have not taken antitrust law, there is a lot for everyone, and you do not need to be immersed in the substantive doctrine to appreciate what antitrust is, because I learned it in earnest as counsel to the AAG at the Antitrust Division of the DOJ. As part of thinking about labor antitrust enforcement, I had to get in touch with the roots of the statute. Right? We got our first antitrust law in 1890. And it is an incredible statute because it is remarkably flexible. It condemns conspiracies and cartels and monopolization and all manner of either unilateral or coordinated conduct that makes markets less competitive. And up to that point, it struck me as a very technocratic exercise. I was very wrong. In the floor debate of the Sherman Act, Senator Sherman, for whom our first antitrust law was ultimately named, really went through a litany of all of the reasons why monopolies are harmful to people, to society, and to the republic itself. But what was striking, I thought at the time, was that in the floor debate, he says, and this is a quote, monopoly commands the price of labor without fear of strikes, for in its field it leaves no competitors. And I thought that was curious because I had learned a lot of antitrust law up to that point, and I was not aware of that many labor competition enforcement actions. And so I went looking for them. And what I found was what can only be characterized as a yawning gap between roughly the 1920s and, save one or two kind of specialized enforcement actions, the Silicon Valley no-poach cases. And so I was curious about why that was, when there was so much support in the floor debate for this law that has outsized significance for our economy, which is the envy of the entire world. And so I went through Senator Edmunds' personal memoirs, and he talked about how he had intended that the statute would not create new principles of law, but incorporate a common law. And all of you are now in law school. Good luck deciphering what the common law actually is. But you should know that that is the way that we incorporate our history and traditions into the substantive law. And what I learned is that in the Anglo-American tradition, there was ample support for this idea that monopolies are bad for individuals, they're bad for institutions, and in some cases, they are essentially a crime against the king. And so I went back and found that there's the case of the monopolies in 1602, right, Darcy versus Allen. And there was this notion that the government grant of monopoly contributed to idleness. And I was curious, what was it about this case that was so offensive to the king? And it turned out there were essentially non-competes, right? Our earliest forms of restraints of trade were non-competes. And so there again, we see concern about labor. We see examples of Senator Edmunds pointing back to, actually in the Darcy versus Allen case, this is very interesting, there is a reference back to Justinian, right, and Roman emperors who had attached opprobrium to monopolies. I thought that was also very interesting. Professor Daniel Crane at Michigan Law School recently edited a wonderful volume about democracy and antitrust, and he says that there are concerns about monopoly and its effects on working people that are reflected in 9th century BCE Chinese thought, early Islamic thought, the Jeremiads of Martin Luther, Aristotle's writing. And so again, we see this very long concern across human history, across very different civilizations about the coercive power of monopoly. And again, it's not just the coercive power of monopoly as to people as consumers, but as laborers and as working people. And I think that is fascinating. I also found support in much more recent history and the writing of Adam Smith, right? This is fairly well known at this point, but all of us sort of come to Adam Smith as, the father of free market economics. We learn about laissez-faire. And then you actually read The Wealth of Nations and the Book of Wages and Labor in particular, and you see that this person who talks about what becomes the free market is also very concerned about monopolies and the treatment of the poor. And there's very interesting writing in there about how masters, which I think is an old way of referring to employers, or what we would conceive of as employers, are always and everywhere in a sort of tacit collusion to maintain wages below their competitive levels, right? That is, again, in the 1700s that you see this kind of writing. I should also add, from the Anglo-American tradition, you see Sir Edward Coke, who believes that monopolies are contrary to the Magna Carta. And so, again, more examples of people who are concerned with the power of private enterprise against, or powerful private enterprise, rather, relative to people. So now we're back to 2016. And so we're crafting a policy at the Justice Department about how we're going to treat the criminal variety of certain labor market conspiracies. And what was fascinating about that time is that it coincided with, I'll say, two forces that are interesting for purposes of our conversation tonight. The first is a sense of agreement about how the economy was working for ordinary people at that time. There were populist forces that were taking hold across the United States. Some people say that it was the two-tiered recovery from the financial crisis, stagnating wage growth, concern about new business formation, high markups, and a general concern about lack of economic opportunity. And we need not sort of get into whether it's real or imagined, right? There's research that will go in different directions. But in our country, and this is the sense that we all have as lawyers in the executive branch, we wield power with the consent of the governed. And so the will of the people is very, very important because it is reflected in our law, and all public officials have to be responsive to how people feel about government, about democratic institutions, and so it can color our approach and our priorities as we think about enforcement of the law. It also brought me to Harvard in 2018, where I met Sharon and a group of folks who were then writing about the importance of antitrust to certain labor market concerns. They were primarily labor economists, but they thought that there might be answers in antitrust to sort of solve this policy crisis around stagnation for a lot of people in this country. And that was a fascinating time. I also looked through old writing from the Obama administration's Council of Economic Advisors, issue briefs, policy statements, and very smart people who had devoted time and resources and substantial research to figuring out why we had not, across the board, sort of recovered from the financial crisis in ways that we might have expected. And in that work, what I learned was about the power of monopsony, concerns about non-competes, concerns about mergers that harm working people, information exchanges, and it ultimately gave me an opportunity to think much more broadly about labor market issues and how antitrust might be brought to bear on labor market issues when my original sort of mandate was to think about the criminal variety of conspiracies. And this was really the honor and privilege of my career thus far. I had a chance to testify before Congress in 2018. And at that point, you have to understand, it was largely an intellectual or academic question, how antitrust could be brought to bear on different kinds of antitrust issues. There were a lot of questions about whether you could challenge a merger based solely on labor market harm. That was an uphill battle. I'm really proud to say that the Justice Department has since blocked an entire merger based solely on labor market harms, right? That was Penguin Random House, Simon & Schuster in 2022, which we were incredibly proud of. Information exchanges. Up to that point, the common thinking was that big diffuse conspiracies were really hard to maintain. And what we found was they actually aren't that hard to maintain, especially when you have oligopolistic markets that are sort of conducive to information flow. One of the high points of my tenure as principal deputy in the Antitrust Division has been challenging poultry processors' information exchanges, where they essentially exchanged information about wages and benefits for slaughterhouse workers who, I need not tell this crowd, are incredibly vulnerable. A lot of them are non-English speaking. Many are undocumented, and they're subject to abuses that I think many folks in this room may not be able to fully comprehend. We are really proud of the fact that we were able to guarantee that $85 million would be set aside to compensate those workers, that the intermediaries through which this information was passed were ultimately banned from the market. And we ultimately got cooperation that helped us secure justice against more poultry processors in addition to Cargill, Sanderson, and Wayne. We also participated in the Supreme Court in the NCAA v. Alston case. We filed an amicus brief on behalf of the United States, and we're incredibly proud to file our brief on behalf of college athletes and to say, finally, after something like 40 years, that price fixing in labor markets is just price fixing, and we were very happy to see that view reflected in Justice Kavanaugh's concurrence. And we were also very happy that was a 9-0 opinion. To wrap these kind of introductory remarks, I would say that it's been an interesting road over the last 6 years, in that what started as a kind of intellectual quandary is now the sort of basic work of the Antitrust Division. We are always thinking about mergers that may harm workers. We will deploy the FBI and agents in the IG community where warranted to go investigate potentially criminal conspiracies. Again, where warranted. We are challenging information exchanges. We are hiring labor market economists and other kinds of experts to make sure that we really understand these markets as they exist. And this is a really it's really meaningful work, I think, for all of you who are considering what to do next. I would say that antitrust is a great career. Antitrust in the public interest is a wonderful life, even if labor is not your thing. Should be your thing, but even if it's not, there are lots of good things that you can do for the public. I think antitrust kind of rhymes with our social, political, and economic ideals. There are really interesting sort of appeals to civil rights era figures and heroes, Bayard Rustin, Martin Luther King, Frederick Douglass, who understood that full participation in our democracy couldn't be secured only with social and political rights, that they had to be backstopped by economic rights in order to make sure that people could participate fully in our democracy. And I think antitrust has something to say about all of those things. So if you are undecided, if you're thinking about something to do for the summer, know that the antitrust agencies are available to you. It is really fun, and the best time to be an antitrust lawyer is right now.
Thank you for that, and I will say, welcome back.
Thank you.
It feels, in a way, like a lifetime ago. We were actually in this room.
Is that right?
Yeah, we were in this room in 2018 when Doha was last year, and we did this conference on labor market competition and antitrust. And if you had told me then the things like that you just talked about would be happening. I mean, I remember being in the White House the first time I went to a meeting about labor and antitrust, and somebody was like talking about monopsony, and I was like looking on my phone trying to figure out what in the world the word meant. And so it has just been a remarkable time, and you know, I will just share, I think Doha really gets a good part of the credit for that, for just pursuing these cases, especially, you know, the poultry processors case is just one that I think is incredibly important. But so here we are, where it is now the norm, at least within our antitrust agencies, to think about the impact on labor markets. And I just wonder if you could say just a little bit more about how that idea has sort of normalized from what I think for a number of years was this focus on impact on consumers and the connection between thinking about the impact on consumers and the impact of monopolies, monopsonies on working people.
For sure. So I mean, as I just recounted, I think that labor market considerations are quite normal, and to the extent there's been aberration, it was in, the late 1970s and 1980s, when a new school of thought prevailed and sort of emphasized that it was really, the price of goods and services downstream, right, for products and services that really mattered for purposes of antitrust. And I do try very hard to be fair to those folks. I think they have bad ideas, but trying to place myself in their shoes. I think that setting aside the kind of anti-democratic pull away from antitrust law as it had been written, interpreted, existed in the common law, there was growing economics. But even there, you see, Joan Robinson was writing about the theory of imperfect competition in 1933, right? She was writing about abuse of bargaining leverage and classic monopsony a long time before, 50 years before that. And so, to me, what's interesting about this moment is that while the lawyers are re-engaging with the text and the statute and the history and the common law, even modern IO economics, I think, readily concedes that monopsony power, one, is real, two, is just as unlawful, especially under Section 7, which is our merger enforcement statute, and that as the labor economists have shown over the last decade or so, that you can have really concerning levels of coercion and power over workers, monopsony power, probably at lower thresholds that you might see in like product markets where you start to get worried about monopoly power. And those are really interesting and important insights that I think can inform policy solutions, even outside of antitrust.
So cool. So you talked obviously about your experience, your home institution, the Department of Justice, but we're really seeing in this rebirth or coming to the fore of antitrust enforcement, especially just saying in the Biden administration. It's not just in the Department of Justice. We obviously have a very innovative leader at the FTC, but there are also the labor agencies are getting involved. Can you talk a little bit about like how that dynamic works, what other parts of the government you engage with, and how the sort of whole of government approach has come together and what you see as the benefits of it?
Totally. So at the risk of being a little immodest, I do think the Biden-Harris administration has really been commendable in the ways that it has given us a mandate to focus on antitrust issues and to pursue enforcement without fear or favor. But I really think some of the genius of our time together has been a competition executive order that the president signed in July 2021. And what was interesting about it is that it declared that the policy of the Biden-Harris administration would be to pursue a whole-of-government competition approach. And you might think, what does that actually mean as a practical matter, right? You have the two antitrust agencies, what else is there? Professor Tim Wu really did a lot of work to uncover the fact that there are myriad competition statutes that dot the US Code. So Sherman Act, Clayton Act, FTC Act, but there are maritime statutes that focus on competition at the ports. The Department of Transportation has a competition authority that lives in Title 49 and looks very similar to Section 5 of the FTC Act. It declares certain practices in the transportation industry to be unfair methods of competition. The Securities Exchange Act at its core is a fairness statute. There are also really kind of curious ones. So I learned that the Panama Canal Act has a provision that declares that you cannot pass through the Panama Canal if you've been convicted of a Sherman Act price fixing conspiracy. Just very odd, but that exists. And so harnessing all of those different authorities, and sorry, I should say the Packers and Stockers Act is a very, very important one that is enforced by the US Department of Agriculture. And I also should have said that the slaughterhouse workers case was special because the Department of Agriculture actually delegated its authority under the Packers and Stockers Act to the Justice Department. And so we were able to file a case under the Packers and Stockers Act, maybe for the first time ever, but certainly for the first time in recent memory. And that was very exciting. And so once you have lots of executive branch agencies thinking about competition in tandem, thinking about practices to promote competition, suddenly you have a force multiplier. What's also interesting is it allowed the Justice Department to take up a fairly traditional role, which is to be the law firm for the entire executive branch. I think we have really enjoyed that role, and we have been proud of the ways that we've been able to vindicate economic liberty, but also vibrant open markets that are conducive to innovation, conducive to investment, so that they can do the kinds of things that we want them to do, which is allocate goods and services effectively, to compensate workers properly, to do all these broad ideals that we have about how economic markets should work. We think that we're able to better effectuate through a whole government competition approach.
I remember clearing that executive order, and I think there were 70 some odd executive actions that were referred to within that executive order. It was quite, it was a stunning piece of work. Have to give a shout out to my friend and former colleague at the NLRB, which is also in on this action as they're trying to use their authority to address non-compete agreements. More complementary action. But I want to turn now to a case that our students had a chance, some of our students had a chance to talk to your staff about, which I think has gotten, at least in my world, a lot of buzz, which is the statement of interest that DOJ filed recently in a private action brought by some employees and former employees of UPMC, and which happens to be, for those of you who don't know, the largest private employer in Pennsylvania. And the allegation is that they've engaged in anti-competitive behavior in a way that has impacted wages and working conditions for employees there, which is thousands. I think there's about 90,000 employees at UPMC. So many of the workers in the pleadings in that private case have told really heartbreaking stories about the working conditions and how some of the practices that they allege are anti-competitive have impacted their lives. And so I'd love for you just to share, we have a bigger audience now, sort of how you came to file the statement of interest, or just a little bit about what this case is. But I think it's I hope, an interesting example of how you engage with private parties and in particular with workers, with unions, with advocates in pursuing your, this area of the intersection between labor and antitrust.
For sure. So I should say, at a broad level, we have an amicus program at the Antitrust Division, and it looks a lot like the Solicitor General's amicus program. We are always looking for questions of law where we think that we can potentially file a brief in the district court, state courts, in the federal courts of appeals, to try to clarify the proper interpretation of the antitrust laws. This has been a big focus for us. It was a big focus under my prior boss, Mekki and the Trump administration, and I suspect it will continue to be very important. And so the UPMC case is interesting. They are not our facts. There's a motion to dismiss pending. But what's fascinating about the case is that they bring a Section 2 claim. And so Section 2 is our monopolization statute. And we essentially say that all of the hallmarks of monopoly, apply in labor markets to where you are alleging a Section 2 claim. And so in the UPMC case, the allegations, which again are taken as true for purposes of a motion to dismiss, were that UPMC accrued power in Pennsylvania by buying up a bunch of provider groups, right? So you see consolidation and potential employers there. And then with that power, they did things such as make it to where you couldn't be hired back by, again, what is alleged to be the largest non-governmental employer in Pennsylvania if you left. They made workers, allegedly, pay for training that they had to pay back, including through garnishment of their wages. Again, if they tried to leave, if they tried not to pay, etc. There were also non-compete agreements that are alleged to have hampered worker mobility. And so we thought that there was an opportunity to come in and clarify how all of those different practices, when done by a monopolist, are unlawful. And there are, again, ways that it rhymes with our digital markets enforcement. We are very proud to have just beaten Google in a very big Section 2 case. Thinking about the standards in Microsoft, where the court says the means of anti-competitive exclusion are myriad, right? When you're talking about a monopoly, also applying labor markets was very important to us. But I want to focus on the last part of your question, which is how do we engage with workers? If you have ever heard the Assistant Attorney General talk, you know that an issue that is very, very important to him is access to justice. It is a fact that large, well-resourced corporations tend to have the most obvious antitrust problems, and they are very good at advocating for their interests before the agencies. But again, as lawyers in the executive branch, as lawyers in the Justice Department, it is very important that we afford opportunities to, again, our fellow citizens, and get out of the beltway and talk to people for whom Washington, D.C. is actually figuratively very far away. It makes us closer to our congressional mandate. It helps us realize the democratic ideals of the department, and it helps us be more faithful stewards of the law. It is our job to administer the antitrust laws as best as we possibly can, and it helps us execute our constitutional obligation to take care that the laws be faithfully executed. So we have thought hard about how to open up access to the Antitrust Division, and thus far, we're open to suggestions, but thus far, we have identified 2 ways that we can do a better job of that. The first is to make antitrust understandable, to use plain language wherever possible. Ordinary Americans probably could not explain to you, to like a technical legal standard, what price fixing is, or what monopsony is, or what the hallmarks of it are. But humans have been transacting business and buying and selling things for like millennia, and most people can tell you what the private coercive power of an entity feels like. They can tell you that when the two biggest employers in a town merge, that they have fewer opportunities. They can tell you that when the biggest healthcare providers consolidate into one, it is harder to get an appointment. It is harder to get someone to call you back. It is harder to get follow-up. And in healthcare, when we were talking about matters like actually of life and death, it is very important that we think about whether we are properly enforcing the antitrust laws and also giving guidance to courts about how they should be thinking about private antitrust claims. And so we try very hard to court, invite a plethora of views. That can be from academics, it can be from industry, it can be from advocacy organizations, it can be from ordinary people. A real high point of our time has been the merger guidelines process. So we updated the document that helps the public understand how we at the DOJ and also at the FTC evaluate mergers. But we went out and did engagement sessions where we heard from doctors and we heard from nurses, we heard from farmers, and it was really a privilege to hear from people how their market experiences were going. And again, it's not to the exclusion of anyone, big corporations, little corporations, fancy people, not that fancy people, we're happy to hear from everybody, right? It makes us better at our jobs. And so we're really focused on hearing from labor advocates who have not necessarily been able to get audiences at the agencies. We're very proud of that.
That's awesome. All right, so I have to ask one more question about UPMC because when we sat here together in 2018, just the idea of looking at labor markets in the context of antitrust was sort of mind-blowing. What has really blown my mind is something that comes up in the UPMC statement of interest, which is looking at collective bargaining and the impact of how a monopsonist power affects collective bargaining rights as a relevant issue. And this resonates through other antitrust actions like the FTC's complaint in Kroger-Albertsons, where a large chunk of that complaint is about the impact that the merger would have on sort of the quality of collective bargaining in that sector. Or Communication Workers of America brought up collective bargaining in the context of their filings about the Blizzard Activision Microsoft acquisition. So can you just talk a little bit about how antitrust enforcement agencies think about the role of collective bargaining as a countervailing power, which is such an antitrust concept?
Again, I would say that Joan Robinson was thinking about countervailing power in 1933. And so the sort of nuts and bolts of the theory are that when you have buyers and sellers transacting business of some kind, if there's a lot of power on one side of the market, one way to deal with the asymmetry is to sort of grant countervailing power, right? And then maybe you get something that seems like a more fair negotiation and you have fewer antitrust concerns. I don't know that there is a singular school of thought in the agencies. I think this is rather new. But I'll make a couple of observations based only on our own enforcement at the Justice Department. I think that it is highly fact specific and it also depends on the antitrust problem. Candidly, I have some concerns about commitments to labor neutrality in the merger context. I have some concerns that it is too speculative for merging companies to both eliminate a competitor but also make commitments about a union vote that is not certain to happen, and where there's still the problem of running into Section 7 of the Clayton Act, where you have a probabilistic statute that says if the effect of a merger may be, again, maybe is in the statute, substantially to lessen competition or tend to create a monopoly, it is our job to block it, right? And I gave a whole speech in early 2023 about why I think Congress understood when it passed that statute that we might ultimately block more mergers than we need to if we had a crystal ball and could perfectly see the effects of mergers. I think it's different when you're talking about, or potentially different when you're talking about business conduct. At the DOJ, we had a case, I want to say in 2023, involving Activision Blizzard, in fact. They make Call of Duty and other kinds of video games, and they actually had an esports league where they set a salary cap on what these esports players could earn. And in addition to enjoining the salary cap, one of the provisions that we put in the decree resolving the case was that Activision had to commit to labor neutrality in the event of a potential vote to unionize. And again, you see examples in sports that crop up a lot. Leagues want to bargain collectively. That tends to work pretty well in most cases when there's a players' union. And so that, I think we had confidence that that would be a good approach on those facts in that league at that time. I'm not sure that I would build out a rule. I think we are always thinking about the facts in the law, and we are also always thinking about the law of remedies in antitrust cases that we are required to meet and engage when we're negotiating remedies for labor market issues.
Interesting. So interesting. Okay, let's open it up to questions. Who has?
Hi, thank you for taking the time to speak to us. I was wondering if you could talk a bit about how you all are thinking about two-sided markets where the apps like Uber or Lyft where workers are on one side and it seems like consumers are on the other. Just generally, how does your agency approach those issues? Is there any recent thinking about them? Thanks.
I'm gonna guess you've taken an antitrust class if you know what a two-sided market is.
I haven't actually.
Whoa, that's amazing. I confess I did not know what a two-sided market was until I became like a fully formed antitrust lawyer, so kudos. Look, two-sided markets are sort of features of certain markets. Platforms, credit cards, for example, we confronted this issue in our Amex antitrust case, but it also comes up a lot in digital markets cases. And we are really fortunate to have been able to hire in expertise. Dr. Susan Athey was our chief economist for a long time in our tenure. And no one has done more to really demystify platform economics, which tend to be multi-sided in nature, than Dr. Athey. And so I think you can look to our Google search case to see that we are not afraid to challenge fact patterns that involve two-sided markets. We are thinking about ways that you can inhibit things like multi-homing, where you can have de facto exclusive supply agreements, for example, on one side of the market that can make competition to displace the platform, competition off the platform, or other ways that platforms can kind of wield power more difficult, right? And where markets may be beholden to the whims of a monopolist. I think we're only going to see more of those kinds of cases in the future. We recently filed a case against Visa. We have another one against Apple, and I expect that we'll confront arguments about how defendants think that two-sided markets are supposed to work, and we will be prepared to meet those challenges in litigation.
Other questions?
Thank you. Just taking it back to the UPMC case. It started with UPMC buying out a bunch of companies that were involved in the same as what they do, and then eventually it transitioned into unfair labor practices, right? So we had a situation where there's like a first level market of what they're involved in, which is healthcare provision and other such. And then the second market within the market, which is the labor market. So by the time you're coming to look at this labor market, you have to first scrutinize what they're into as a service provider. By the time you're looking at the labor market being violated, as is the case, people will perhaps have gone to a labor department instead of to the Department of Justice with respect to antitrust, because the common man will think that this is a violation in terms of labor rather than an antitrust violation. My question to you is, do you have a desk, do you have a synergy with the Labor Department as the Antitrust Division to be able to look out for situations like this on the regular? That's number one. Number two, sensitization. By the time the common man realizes that this is an antitrust violation, beyond just a labor market violation, much time may have passed. They may not even know that their remedies reside in antitrust law. So my questions, just to summarize it, is number one, do you have a sensitization campaign that exists within the labor market as antitrust? Like, have you partnered with them? And what's the sensitization to the common man with respect to their labor being an actual market? Thank you.
This is such a great question. So the answer to your first question is yes. We have great working relationships with the Department of Labor, with the NLRB, but also at the state level, where a lot of these labor violations or alleged labor violations are likely to be surfaced in the first instance, and we are hearing about them there. We have actually entered into memoranda of understanding with both the Labor Department and the NLRB to make sure that both when we are looking at conduct that we are availing ourselves to data sets that they are keeping, which can be invaluable for an antitrust analysis, but that we are also committing to work together when mergers come along that raise labor market questions. What I like so much about your second question is that it sort of acknowledges that labor market concerns may or may not fit into one basket. And one big challenge, one huge policy challenge we have in the United States is that the issues facing workers are myriad, right? When workers have problems, I can typically identify a failure of tax policy, a failure of monetary policy. The fact that we don't have comprehensive labor protections just like on their own terms. And so antitrust becomes appealing, probably because the antitrust laws are very flexible, but we know, much as we wish it was not the case, that antitrust is not a panacea, right? And so we are, again, thinking about fact patterns that might trigger antitrust concern, but we do not have a hubris problem. We know that we cannot fix every labor market issue. In terms of public education, we try to get out and talk to people. I spent years when I was special counsel for labor and counsel to the AG, talking to every audience I could to try to get the word out that antitrust and the antitrust agencies in particular were concerned about labor market issues. But I won't lie to you, it's really hard. When Congress is appropriating budgets, they are not lavishing funds on us to go out and educate the public. Again, much as I wish that was not the case. And so we can be better for sure, and it's something we're going to have to keep working at. I'm hopeful that the Access to Justice initiative will help us talk to more people and also surface more concerns.
So what drew you to antitrust to begin with? I mean, if you didn't start, I mean, you speak so passionately about looking out for working people and ensuring that they're being treated fairly, but you didn't come in through a labor door. So what made you go into your career through an antitrust door?
Do you want the polite answer or the honest one?
I want the honest one, because I'm way more interested.
So I've already confessed that I never took an antitrust law class. I went to Penn for law school, and the tradition at Penn is that you spend your 1L year sort of writing class, working on a brief, then you go down to the Third Circuit and you argue it, one side or another of the issue. And that year, there was an antitrust fact pattern. It was like some college bookstore was like bundling ebooks or something, offered a discount, a private bookseller was injured and had sued. And so I sort of went through that like morass of bundle discounting law and like Parker versus Brown immunity, and ultimately thought antitrust is probably great for some people, but I probably was not one of those people because it seemed very technocratic. That there was a heavy econ focus, and I thought maybe I could spend my time doing something more meaningful. I took the bar, and again, talk about the financial crisis. Firms were teeny tiny in their classes. I felt so lucky to even have a job. And before I started, or I was officially slated to start, the law firm called and said, "Are you willing to start early? We represent AT&T, and we are trying to acquire T-Mobile, and the antitrust division just filed a lawsuit to challenge it." And I said, okay. And I can't emphasize enough, I showed up at my firm not knowing where to find Section 7 of the Clayton Act, like truly knowing nothing about antitrust, but it was exhilarating. I mean, the merger was abandoned, but I still found it so exhilarating. Learning about product markets, getting executives ready for testimony, thinking about like what the government knew and which witnesses they were going to put up, and just thinking about all of those issues was so fun. And so I then had a chance to do more counseling, private litigation. I did criminal work, civil work, and I loved antitrust. And I should say I worked at the U.S. Attorney's Office one summer. I think found out pretty quickly I'm a mission-oriented person. Go to the government, there's this thing called sequestration where there's basically no government hiring for about 5 years. And so once sequestration was lifted and the government was finally hiring again, I was sitting in my office at the firm, and one of Bill Bayer's deputies gave a speech about how the antitrust division was going to hire younger lawyers. And I was incredibly fortunate to be hired into the department in 2015, and I can't say enough, I love the department. I think all of you should work at DOJ, somewhere, the Civil Rights Division, the Tax Division, the Civil Division. It is awesome, it is a good life, even if antitrust is not your thing. But again, I hope it is. You should come to the Antitrust Division because it's awesome. Look, here's my pitch for antitrust at DOJ. In a little finer detail. While the position of Attorney General has existed for a very long time, since the founding, the Justice Department itself is a Reconstruction institution. It was founded to protect the civil liberties of freed slaves and to see to it that the 13th, 14th, and 15th Amendments guarantees would be enforced. And about 20 years after the department is founded, you get our first antitrust law. And again, I've just taken you through all of this concern about coercive power and why it is a threat to individual liberty, but again, also a threat to the republic itself, where we have Supreme Court cases where Thurgood Marshall says, the antitrust laws are as important to our economic liberty as the Magna Carta is to some of our civil liberties. I mean, this is really, it is an exciting field, and the interconnectedness to, our most sacrosanct ideals is really special.
there's questions in the.
Hi, so I work a lot with students here at the law school. I actually also went to Penn for law school. And one of, a lot of our, whether it's CLJ or the LP program, are applying to honors attorney programs and things like that. And a lot of them have had anxieties both last year and this year about what it would be like under a change of administration to join the federal government right now, even in cases, where I feel like this is sort of insulated from maybe some of the worst, like the particular departments are maybe a little bit insulated from the worst impulses of potential change in administration, but that they're like, oh well, for moral reasons or for other reasons, I don't want to have that sort of scarlet letter of being under a particular administration. I guess what would you say to them, or what would you recommend us do?
I appreciate that question so much, and I've heard variants of it before. Here's what I would say, but first, disclaimer. I said that I joined the department in 2015 as a career public servant. I did not share that I converted to becoming a political appointee in order to do my job. As the second highest ranking official in the Antitrust division, I did work for Republicans and Democrats. I've been a counsel to a Republican AAG, and now I serve as principal deputy to a Democratic AAG. And what I would say is that the Justice Department has a long and storied history of enforcing the law without fear or favor, again, executing on our constitutional obligation to take care that the laws be faithfully executed. And that work, by and large, is done by nonpartisan, expert career staff. And it is the expectation in the department, and I know this firsthand for having been a career public servant, that regardless of who is in charge, we give the best advice that we possibly can. We know that integrity is ours, right? Institutions are just made up of people, and that we, take care with the awesome power of the United States and the government that we're entrusted to kind of enforce. And there were unfortunate stories about sort of ethics issues, whistleblower issues, and the like. It is the rare case, and it would be my expectation that norms continue because people, nonpartisan people, continue to do the work day in and day out without regard to who is in charge of the agencies. So I still think it is a good life. And again, as a sitting public official, I can't sort of talk about election outcomes or consequences, but I would say that there's always a role for nonpartisan, expert, hardworking career staff, and that is the case at DOJ. The staff are exceptional, and they do the work that actually matters, again, regardless of who is actually in charge of the place.
Any questions? I have one more question, but I feel like you can't have a panel on any topic these days without bringing up AI. It is ubiquitous in our lives, and I think a lot of folks here are trying to imagine how the law is going to play a role in the development of both the companies and the technology and how it intersects with all our lives. So is that something that the division is thinking about? I'm not asking you to tell us what cases you're going to bring, although I will note that there are not a lot of competing companies in that sector. You can just nod if you want. But no, just curious, sort of, are there aspects of the development of this technology, the way it's being deployed, that are catching your eye and you can see a role for the division going forward?
Yeah, so artificial intelligence is a really interesting inflection point, especially as deep learning technology really advanced after like the 2010s or so. I think we're seeing some consumer-facing products, ChatGPTs and the like. One of the big lessons from our observations about digital markets and sort of the first instantiation of the internet was that we likely were not sufficiently sensitive to choke points, to opportunities to wield market power, and the ways that digital markets in particular are prone to tipping and may have characteristics that make them different from traditional or more widgety markets. We have a number of cases that are pending in digital markets, including our recent Google search case. And one of the things that I think the Assistant Attorney General and I have publicly talked about is that if you were to be in the business of creating large language models, having a search index and access to a lot of content maybe gets you a lot of the way there, especially if you can mount the resources to have the compute and put forward these substantial resources to train large language models. And so one of the things that we are always thinking about is making sure that the competition that is available today is not the high watermark of competition in the future. And so I think we are all thinking about ways to be more vigilant. I think there are lots of really exciting use cases for AI. Candidly, one thing that I am thinking about, because I'm always thinking about working people, I'm always thinking about producers, content creators, songwriters, actors, authors, laborers, and the whole kind of like spectrum of working people and producers is, if large language models are able to hoover up work that is very expensive or costly in terms of time investment, and ultimately makes it such that there are fewer incentives to continue creating those goods, that feels like a substantial loss. Again, Joan Robinson is my unofficial hero. Joan Robinson was writing about exactly this kind of problem, again, in the 1930s, right? Like this is a variant of the monopsony problem. And so I think that there are ways that policymakers can be thinking about continuing to incentivize those really important works, again, things that go to our social, political, and economic ideals, to make sure that they survive beyond this inflection point. I think there's an opportunity for industry also to think about how they can properly compensate that work and continue to make sure that there's production of music, film, books, and other really important aspects of American life.
Great, well, please join me in thanking Doha for being with us.